MLC 2006 is organized into 5 main titles. Title 1 covers minimum requirements for seafarers to work on a ship, including age, medical certification, training, qualifications, and recruitment. Title 2 governs conditions of employment, including employment agreements, wages, working and rest hours, leave entitlement, repatriation, and compensation. Title 3 addresses accommodation, recreational facilities, food and catering. Title 4 ensures health protection, medical care, welfare, and social security protection. And Title 5 details compliance and enforcement, including flag state and port state responsibilities, inspections, and complaint procedures. These 5 titles collectively protect seafarers' rights, working conditions, living standards, health, welfare, and legal protection. One of the most important compliance tools under MLC 2006 is the Maritime Labor Certificate and the Declaration of Maritime Labor Compliance, commonly known as the DMLC. The legal basis can be found in Article 5 and Regulation 5.1.3. Article 5 requires each member state to ensure that ships flying its flag carry a Maritime Labor Certificate and a Declaration of Maritime Labor Compliance where required. Regulation 5.1.3 then specifically deals with the Maritime Labor Certificate and DMLC as part of flag state responsibilities. These documents are important because they provide evidence that the ship has been inspected and that its working and living conditions comply with MLC requirements. For certification, the main requirement applies to ships of 500 gross tonnage or above that are engaged in international voyages or operating between ports in different countries. These ships must carry a valid Maritime Labor Certificate and DMLC on board. During port state control inspections, the certificate and DMLC may be accepted as initial evidence of compliance. This is supported by Regulation 5.2.1, which states that port inspections may review the Maritime Labor Certificate and DMLC to determine compliance with the convention. Therefore, the certificate is not just an administrative document. It is a practical enforcement tool used to check whether seafarers are protected in terms of employment agreement, wages, rest hours, accommodation, food, medical care, welfare, and complaint procedures. The next important area is MLC insurance, also called financial security. The legal foundation is mainly found in Regulation 2.5 and Regulation 4.2. Regulation 2.5 deals with repatriation, which means the right of seafarers to return home. It states that seafarers have the right to be repatriated at no cost to themselves in the circumstances specified by the convention. And ships flying the flag of a member state must provide financial security to ensure repatriation. This is important because seafarers may work far away from home, and if their employment ends, if they are abandoned, or if they cannot continue their duties, they should not be left stranded in a foreign port. Regulation 4.2 deals with ship owners' liability. It requires ship owners to protect seafarers from the financial consequences of sickness, injury, or death connected with their employment. This includes medical care, support, and compensation where required. Therefore, MLC insurance is not only about sending seafarers home. It also protects them when they suffer occupational sickness, injury, death, or long-term disability. In practical terms, this financial security ensures that seafarers have real protection even if the ship owner becomes insolvent, refuses to pay, or fails to fulfill his responsibilities. In Malaysia, MLC 2006 is implemented through the domestic legal framework, especially the Merchant Shipping Ordinance 1952, or MSO 1952, as amended. After Malaysia ratified MLC 2006, the MSO 1952 was amended through the Merchant Shipping Ordinance Amendment Act 2016 to align Malaysian law with MLC 2006. The amendments were intended to cover areas such as manning and qualifications, seafarers' conditions of service, wages, health, accommodation and provisions, and discipline. This shows that Malaysia does not merely accept MLC 2006 at the international level. It also incorporates the convention into national maritime law so that it can be applied and enforced on Malaysian ships. Besides the MSO 1952, Malaysia Shipping Notices, or MSNs, also play an important role. MSNs are practical instructions issued by the Malaysia Marine Department to guide ship owners, masters, operators, recognized organizations, and seafarers. For example, MSN 09-2016 deals with the MLC financial security requirements relating to repatriation and ship owners' liability. It states that the requirements for financial security for repatriation and ship owners' liability are included in the DMLC Part 1, and ship owners are required to apply for the DMLC Part 1 and submit an MLC shipowner declaration. The latest Malaysian implementation can also be seen through MSN 08-2024 issued by the Malaysia Marine Department. This notice addresses matters relating to the 2022 amendments of MLC 2006. The 2022 amendments entered into force on the 23rd of December 2024. According to the ILO, these amendments were introduced to improve seafarer protection after challenges such as the COVID-19 crew change crisis. They strengthen areas such as recruitment and placement, repatriation, medical care, health and safety, food and catering, and access to social connectivity. This shows that MLC 2006 is a living instrument that continues to evolve according to current maritime labor challenges. In addition, the ILO has already approved the 2025 amendments to the MLC 2006 Code. These amendments are expected to enter into force on the 23rd of December 2027, in accordance with Article 50 of MLC 2006. The 2025 amendments focus on newer concerns, such as violence and harassment on board ships, recognition of seafarers as key workers, shore leave, repatriation, fair treatment of seafarers involved in maritime accidents or alleged crimes, and updated medical information on board. Although these amendments are not yet in force, they show the future direction of maritime labor governance. Seafarer protection is becoming more detailed, more human-centered, and more responsive to real problems faced at sea. Therefore, the relationship between MLC 2006, MSO 1952, and MSNs can be understood as a legal implementation chain. At the international level, MLC 2006 sets the global standard for seafarer protection. At the domestic legal level, MSO 1952, as amended, gives legal effect to those requirements in Malaysia. At the administrative level, MSNs provide practical guidance on how ship owners and operators must comply with the requirements. Finally, on board the ship, compliance is shown through the Maritime Labor Certificate, DMLC, and Financial Security Certificates. This chain connects international law with actual protection for seafarers on board ships. In conclusion, MLC 2006 is an important part of Malaysia's maritime governance framework because it protects the people who operate ships. It ensures that seafarers are not only treated as labor resources, but as human beings with legal rights to safe work, fair employment, decent living conditions, medical care, repatriation, and financial protection. Through the ratification of MLC 2006, the amendment of MSO 1952, the issuance of Malaysia shipping notices, and the requirement for MLC certification and insurance, Malaysia demonstrates that modern maritime governance is not only about vessels, cargo, ports, and pollution prevention. It is also about protecting seafarers, who are the backbone of the global shipping industry. Based on the particulars of UUM this vessel is required to have a Maritime Labor Certificate, MLC certificate, and Declaration of Maritime Labor Compliance, DMLC, under the Maritime Labor Convention 2006. The ship is a commercial oil tanker with a gross tonnage of 28,927 GT, which exceeds the 500 GT threshold specified for MLC applicability. It is also on an international voyage, further meeting the criteria for MLC compliance. With 35 crew members, including the captain, all personnel on board fall under the seafarer definition in MLC 2006, meaning their employment, wages, rest hours, accommodation, medical care, and welfare must comply with the convention. Additionally, UUM flies the Malaysian flag, and Malaysia has ratified MLC 2006 and incorporated its provisions into domestic law through the Merchant Shipping Ordinance 1952, Amendment Act 2016, and supporting Malaysia Shipping Notices, MSNs. This legal framework mandates that Malaysian-flagged ships carry the MLC certificate and DMLC and provide financial security to protect seafarers in cases of repatriation, sickness, injury, or death. Therefore, given its size, commercial status, international operation, crew complement, and flag state obligations, UUM is legally required to comply with MLC 2006 and hold the necessary certification to demonstrate that seafarers' rights and welfare are protected.
Thank you for watching. See you next time.